Wars have been fought throughout human history, but did you know there are internationally agreed rules about how those wars must be conducted? Today we are breaking down one of the most important legal frameworks ever created, the Geneva Conventions, what they are, where they came from, what they actually say, and why they still matter in conflicts happening right now. Let's start at the very beginning. For most of recorded history, there were no universal rules about how wars should be fought. Some civilizations showed compassion toward the injured and innocent, while others did not. Warfare was brutal and largely ungoverned at the international level. That began to change in the mid-1800s. According to historical accounts, in 1859, a Swiss businessman traveled to northern Italy and witnessed the aftermath of a devastating battle. Horrified by the suffering of tens of thousands of wounded soldiers left on the battlefield with little to no care, he launched a campaign to change how the world treated the victims of war. He helped found an organization that would become the International Committee of the Red Cross, known today as the ICRC, and he pushed for an international agreement to protect wounded soldiers. His efforts led directly to the first Geneva Convention, adopted in 1864, attended by 16 nations. That agreement established obligations to provide aid to all wounded soldiers regardless of nationality, the protected and neutral status of medical personnel, and a universal symbol, a red cross on a white background, to identify humanitarian workers and facilities. But one agreement was not enough. Wars evolved, and so did the rules. A second Geneva Convention extended those principles to war at sea. Then, following the catastrophic human cost of the First World War, a 1929 convention established specific protections for prisoners of war, requiring that they be treated humanely and that prison camps be open to inspection by neutral parties. Still, the agreements had major gaps. World War II exposed those gaps in devastating fashion. The sheer scale of civilian suffering, mass atrocities, and crimes against humanity shocked the international community. According to Britannica, inspired by the revelations of the Nuremberg and Tokyo war crimes trials, world governments convened a major diplomatic conference in 1949. Between April and August of that year, 63 governmental delegations gathered in Geneva, Switzerland. The result was the adoption, on August 12, 1949, of 4 distinct treaties that together are formally called the Geneva Conventions. So what do those 4 conventions actually say? Here is a breakdown. Convention 1 focuses on protecting wounded and sick soldiers on land. It requires that injured combatants be collected and cared for, regardless of which side they are on, and that medical personnel and facilities be protected from attack.
Convention 2 extends those same protections to wounded, sick, and shipwrecked members of armed forces at sea, including protections for hospital ships. Convention 3 governs the treatment of prisoners of war. According to the ICRC, the third convention requires humane treatment at all times. Prisoners cannot be prosecuted simply for participating in the armed conflict. They are entitled to adequate food, access to relief supplies, and basic protections. Pressure to extract more than a minimum amount of identifying information is also prohibited. Convention 4 is perhaps the most significant expansion from earlier agreements. It specifically addresses the protection of civilians in wartime. According to legal experts, it forbids actions including the deportation of individuals, the taking of hostages, torture, collective punishment, and discrimination based on race, religion, nationality, or political beliefs. It also provides protections for civilians in occupied territories. Together, according to the International Committee of the Red Cross, these 4 conventions protect people who are not taking part in hostilities, including civilians, health workers, and aid workers, and those who are no longer able to participate, such as wounded or captured soldiers. Now here is something critically important to understand. The Geneva Conventions also introduced a concept called Common Article 3, a provision that appears in all 4 conventions. This article functions, according to legal scholars, like a mini-convention within the larger framework. It applies even to non-international armed conflicts, meaning civil wars and internal conflicts, and it requires humane treatment for all individuals in enemy custody, without discrimination. It expressly prohibits murder, torture, the taking of hostages, and unfair trials. In 1977, 2 additional protocols were adopted to update and expand the conventions, particularly to address conflicts involving armed groups fighting against colonial domination and to extend protections in civil wars. A third protocol, agreed in 2005, recognized an additional neutral humanitarian emblem called the Red Crystal, joining the Red Cross and Red Crescent. As of today, the four 1949 Geneva Conventions have been ratified by 196 countries, making them among the most widely ratified international agreements in history, alongside the United Nations Charter. According to the ICRC, much of the law contained in the conventions has also become customary international law, meaning it applies even to states and armed groups that have not formally ratified the treaties. So what happens when the rules are broken? The conventions define specific violations as, quote, grave breaches. These include willful killing, torture, inhumane treatment, and the extensive destruction of property not justified by military necessity.
According to the conventions themselves, states that have ratified them are obligated to either prosecute those who commit grave breaches or extradite them for trial elsewhere, regardless of their nationality. At the international level, the International Criminal Court, the ICC, established in 2002 under the Rome Statute, plays a central enforcement role. According to the ICC's own documentation, war crimes are defined as grave breaches of the Geneva Conventions and include acts such as the killing or torture of civilians or prisoners of war, intentionally directing attacks against hospitals, and the use of child soldiers. The ICC serves as a court of last resort. It steps in, according to its founding statute, when a state is unwilling or unable to genuinely prosecute suspects itself. It is worth noting that some major nations, including the United States, China, Russia, and India, are not parties to the Rome Statute, which experts say limits the court's reach. These conventions have been invoked in many of the world's most significant conflicts. According to reports, they apply to recent and ongoing non-international armed conflicts, including conflicts in Afghanistan, Iraq, Syria, Ukraine, and the Israel-Hamas war. In each of these situations, international organizations, governments, and courts have referenced the Geneva Conventions when assessing allegations of violations. Now let's talk about the modern challenges these conventions face, because they are real and significant. The conventions were written in 1949, decades before the internet, unmanned drones, or cyber warfare existed. According to security and international law experts, advancements including cyber warfare and precision strike drones are reshaping conflict in ways that test the applicability of international humanitarian law. Cyber attacks, for instance, can blur the line between civilian and military domains, raising serious concerns about civilian protection. A cyber attack on a hospital network or power grid, for example, could cause widespread civilian harm without a single weapon being fired. Experts have also raised concerns that drone technology, while allowing for more precise strikes, introduces risks of misidentification and civilian casualties that existing frameworks were not designed to fully address. Academics and legal scholars have called for updated frameworks to address these emerging threats, and some have proposed something that could be called a digital Geneva Convention for cyber warfare. As of now, no binding international agreements specifically govern cyber warfare, though researchers note that the core principles of existing humanitarian law, distinction between combatants and civilians, proportionality, and the prohibition of unnecessary suffering, are broadly accepted as still applying in the digital domain. So why does all of this matter?
The Geneva Conventions represent the world's most comprehensive attempt to place limits on the barbarity of armed conflict. They do not prevent wars from happening, but they set a floor, a minimum standard of human dignity that the international community has agreed must be maintained even in the most extreme circumstances. They protect soldiers who surrender. They protect the wounded. They protect civilians who had no say in whether their country went to war. And they establish that violations carry consequences. The ongoing challenge is enforcement. The conventions depend heavily on the willingness of states to comply and to hold each other accountable. Critics point to the ICC's reliance on state cooperation for arrests, a relatively limited number of convictions, and the non-participation of several major powers as structural weaknesses in the system. But supporters argue the framework still creates meaningful legal and reputational pressure on all parties to conflict. What to watch for next? As active conflicts continue around the world and new technologies reshape the nature of warfare, international legal bodies, including the ICRC and the United Nations, are actively examining whether the Geneva Conventions need to be formally updated or supplemented to remain fully relevant in the 21st century. The debate over how to regulate cyber warfare, autonomous weapons, and artificial intelligence on the battlefield is already underway, and the outcome will determine what the rules of war look like for generations to come.
If you want to stay informed on international law, global conflicts, and the stories shaping our world, follow this channel for clear, factual coverage every day.